Welcome and thank you for standing by. At this time, all participants are in a listen-only mode. During the question and answer session, please press star and 1 and record your name. Today's conference is being recorded. If you have any objections, you may disconnect at this time. I will turn the meeting over to Ms. Melissa Grasso. You may go ahead, ma'am.
Great. Thank you so much, and welcome back, everyone, for another deep dive in our 201 series. Today we're talking about BIS, some more in-depth issues. I know most of you have been with us before and have signed up for a series. Just a quick reminder that we do have some upcoming webinars throughout the rest of July as well as throughout the month of August. A couple quick housekeeping items. We will have a Q&A session at the very end of the three presenters' presentations today. If you do have questions that you'd like to ask, you can always type those in and we'll address those at the appropriate point. And as with our previous webinars, we will be sending out PDFs of the presentations as well as a net replay. So I'd like to first thank our great speakers from the Department of Commerce's Bureau of Industry and Security. I'm just going to give you a little bit of an overview and some context as to who our speakers are and where their expertise is. So first we have Stephen Holl. Stephen has been with the Bureau of Industry and Security since October of 2010. And his duties include outreach programs for the Export Control Reform Initiative, technology transfers, and deemed exports activities. He also serves as the Federal Designated Officer for the Emerging Technology and Research Administration Committee. Prior to joining BIS, Stephen was with the U.S. Department of State, specifically with their export control and related border security program. And prior to his time at the Department of State, Stephen was an export compliance officer for Boeing's missile defense program. So we're pleased to have Stephen with us today. Our two other speakers, I'll just give a bit of background on them as well. We have Timothy Mooney, who is a Senior Export Policy Analyst out of the Regulatory Policy Division of BIS. He has been with BIS since July 2004, and as a Senior Export Policy Analyst, he's responsible for drafting rules to revise the EAR. And since 2004, Mr. Mooney has drafted 87 rules that have amended or requested public comments on the EAR. So we're pleased to have Tim with us as well. And finally, on the docket for today is Peter Zoobi, who is the Acting Unit Chief for the Administrative Enforcement Unit of the Office of Export Enforcement, also under BIS. Before becoming a special agent for the Office of Export Enforcement, Peter served as a special assistant to the Assistant Secretary for Export Enforcement and also as a compliance officer in the Office of Anti-Boycott Compliance. And prior to joining Commerce, Peter served in the U.S. Marine Corps as a judge advocate, civil law officer in charge, special assistant to the U.S. Attorney, specifically for the District of South Carolina, and as a series commander at the Marine Corps Recruit Depot, also in South Carolina. Peter continues to serve in the U.S. Marine Corps Reserves at the rank of major and as a judge advocate and instructor. So as you can hear, we have a great panel of speakers today, and again, we're pleased to have them all with us. So, Stephen, I will turn things over to you. Thank you again for joining us. You should have control now, Stephen.
Thank you very much, Melissa, and welcome and good afternoon for those participating in the webinar. It's one of a series, as Melissa mentioned, on export control issues that we have in other areas. I understand that previous today there was one presentation done by our colleagues at the OFAC, the Office of Foreign Assets Control itself. But I welcome all the participants on this webinar. My name is Stephen Holl. I'm with the Office of Exporter Services here at the Bureau of Industry and Security here in Washington. Part of our jobs, as Melissa mentioned, is an outreach. It's a very important part of our mission here at BIS to get the word out to industries on the export administration regulations and all the ramifications involved into it. And this afternoon, I think we're going to have a very good overview of more of an in-depth analysis of the export administration regulations itself. This goes beyond sort of the parts that people know about in the beginning, but as you'll see in my presentation, it's important to just get an overview, especially for those listening in that may not have an in-depth knowledge on the export administration regulations and here at BIS. So it's good to give an overview of that as well. My colleague Tim Mooney here today will be going actually into the deep dive, in-depth part of the EAR. There are a lot of things happening with our regulations and policy issues that he will be going into in quite a lot of detail, and will probably be taking much of the time here. And we welcome your comments, your questions at this time, too. As I mentioned, one of the things that we try to do at the beginning is to answer the age-old question of you need an export license or not. We are certainly here to answer a lot of those questions, and you may already have a familiarity on this. But one of the things that I'll be providing here is the kinds of questions that we are receiving from industry about the licensing procedure, the EAR itself, and some tips that can make it easier for you as you're applying for licenses that we have certainly seen here when talking to our licensing officers, in addition to current events and current issues that affect the processing of a license, and also to find out if you even need a license in the first place. So one of the things that we look at here is to make a determination as to the myriad of agencies that may be involved into here. And you got an idea the other day from one of our colleagues at the Department of Treasury. As many of you probably have been aware, a few years ago we did have a movement of items being transferred from the State Department to the U.S. Department of Commerce's Bureau of Industry and Security. Primarily of military-related, or what we call our 600 series of products. This is a classification that we use in the Export Administration Regulations, or EAR. At this time, the State Department, our colleagues at the State Department and DDTC, Defense Trade Controls, still is involved with those items of a military nature. And Tim will be talking a little bit more about specially designed issues that certainly a lot of industry has queries about, and it's a fairly complex area, but we'll certainly do that. So our colleagues also at other agencies, at the nuclear regulatory agencies and other smaller agencies, also have export licensing capabilities. But for the most part, the majority of the licenses are being reviewed by the state and us here at the Bureau of Industry and Security, and at the Treasury Department as well, Office of Foreign Assets Control too. One thing that I wanted to point out was our BIS website at www.bis.doc.gov. I wanted to take at this time to get you familiarized with some of the areas of the website that aren't particularly well known within companies, and yet offer a fairly rich bit of information that is oftentimes overlooked. And certainly looking at the website itself, which is constantly updated because of current country policy issues and regulations issues, is, I think, important to take a look at, especially in the area of some of our frequently asked questions. For example, we recently added a section on changes on Cuba as a result of recent proclamations by the President, and we get a lot of calls about that area, so we've addressed some of those questions on our website as well. So as you'll see there, we have a number of different icons representing different parts of the website, which you're look at here. The ones that I would suggest you take a look at in a little bit more detail, especially of those that have maybe newer employers too, they can't always make it to our events. We do have what we call our interactive tools, or our decision tools, which is on the top part of the row there. When you click onto that, you'll see a number of decision-making tools, which will make it a little bit easier for you in determining licenses, specially designed, and use of other areas of the EAR itself to use it for. Okay, so when we take a look at basic licensing requirements, we're looking at, obviously, where it's going to, who's getting it, who's receiving it, and end use. That's fundamental to our purpose. Although this may be somewhat elementary to many of you on the phone, it is important as you are applying for an export license for you to tell us this kind of information, especially its end use itself. You may find that a product in your that you make may have a use which you're familiar with, but it could also be used for other purposes as well. So we're certainly wanting to find out its end use and obviously who is receiving it as well. On the basis of that, again, we look at where it's going and the terms of country it is, who is getting it, and seeing if they are on any of our entity lists or denied persons list, and also, as I mentioned, its ultimate use as well. Although this document, this particular slide may look very complicating, it is a graphic to give you an idea of the process involved in making a decision on an export control item or not. We won't go into a lot of detail on this at this time because you're probably familiar with the procedures, but bear in mind that things are changing all the time. An item that may be EAR 99 now could be indeed controlled in some way, as we've recently seen with our sanctions with Russia, especially in the oil and gas industry itself. So it is imperative for those that are doing this on a full-time basis to really take a look at the website, to take a look at the changes that are coming down the pike, and that's what Tim's going to be looking at a little bit more in detail shortly here. So when we look at our classification, for those familiar with the State Department, our classification is a bit different. When we classify items for an export control purposes, we have it as a category, usually 1 through 9, a categories group as well, depending on if it's material, if it's technology, this kind of thing, and the type of control. Usually, if it has like 600 series in our CCL, Commerce Control List, it will signify that this is an item coming from the State Department itself. And a frequent question that many of us get is for those that have used State Department licenses in some way, that they may get notification that this product has now gone over to the State Department. But many companies are still wanting to are concerned as saying, is my product controlled by the State Department or by the Commerce Department? And our commodity jurisdiction process, which is actually administered by the State Department, is designed to answer that question. So when when you're submitting information to the State Department asking if it's controlled by them or us now, you will get a response from the State Department either saying it's retained by us or that it has now been migrated over to the U.S. Department of Commerce's Bureau of Industry and Security. So, as I mentioned, one of the other areas in our website is the decision tree tools, which acts as an interactive mode for you to get involved and know about our order review, if licensing are necessary, especially designed, a frequently asked question area, and Tim's going to be looking at that a little bit more here. Our strategic trade authorization, which is a new exemption that we have. We will be talking about exemptions in another webinar in about 2 weeks' time itself. And an area in de minimis, and we'll be looking at de minimis itself, a frequently asked question, a very in-depth analysis of the use of de minimis, because we do get a number of inquiries about that. It can be confusing. We'll try to straighten it and clear it up for you there. Please bear in mind that our sanctions and incomprehensive embargoes lists are there. We ask for you to take a look at them. They are, in many cases, changing, as we have seen for the Russian industry sector sanctions that has come up in the Crimea region itself. Please be aware of this. They are very important, and they change to some extent. We also saw it changing with Cuba as well. So imperative that you do keep track of those areas too. Another part of where we are involved in here, and we closely ask for those companies on this webinar, if you've not done so already as part of your standard procedure or part of your compliance plan, to make a note of dealing with your consolidated list. For those on the webinar, this is an extremely important area, not only if you need a license, but also for those that you don't. That's why this particular screening mechanism is very important for those companies who may find that a company overseas they may have doubts about, or that they are potentially looking at exporting either EAR 99 items, which is items not requiring a license, not going to sanctioned countries, or those that would require a license anyway. This is usually one of the first things that you can do to help us by looking at the list, either in an entity list that you have or a denied person. So it's always a good idea to take a look at that to see if any of the information companies that you may have are on there. Again, please note, these lists are constantly changing. You will find in the Federal Register frequent notices of companies being added to the list. It is imperative that you take a look at those lists. Please go on our website, look at the consolidated screening list that we have there, or any other vendor that you may purchase as a third party this information. So we earnestly ask you to do that. If there is companies that are on there or individuals, there's a good chance that your application would be denied. So something to think about, and please look at that on a regular basis. Look at what your end users are. We talked about that at the beginning itself. We've recently added changes to the military end use for Russia and Venezuela, so please, as well as the People's Republic of China too. So look at that. Those are fairly new items as well. We oftentimes like to ask people to take a look at the Commerce Control List too. It's a very good site to check if your product is on our list. It's the Commerce Control List alphabetical list is somewhat of a general nature. You can certainly look at that, but we encourage you to take a look at the CCL, making a determination either by yourself or through us. We can make an official classification determination for you on what the correct ECCN number is for your product. And we're going to find out, Peter's going to be looking at Know Your Customer and some red flags you should be looking at as well that should be part of your compliance program itself. Probably the most important slide you want to have today are contact information too, and I think you'll find this of use if you have questions about what we're doing, changes, or things that may come about as a part of your role as export licensing, export administrators itself. I wanted to also just mention a couple areas that we constantly see from those have been doing this for a number of years, some issues, and I'd like to just go into them to give you some idea about how we tackle those ones. Very common area is license encryption, and we've had some recent issues with the intrusion and surveillance items. You can find out more information on the policy guidance on that and FAQs on that in the website under policy guidance and the frequently asked questions for encryption. By the way, if you're looking at other FAQs in that category, they are also dealing with Russia, Cuba, deemed exports, encryption, entity list as well. There's some frequently asked questions dealing with that, and our new definitions rule itself. I would also ask you to take a look at our recent and up-to-date current seminar schedule. Since we are dealing with an in-depth nature of the EAR, we do conduct on a fairly regular basis some fairly in-depth seminars and meetings on specific issues of the EAR itself. For example, you will find that if you go into the website and take a look under compliance and training and current seminar schedule, you'll notice that we do indeed have a number of courses of our complying with U.S. export regulations. And this has been around for a while, and I think you'll find this of use for those who want more in-depth knowledge on it. But we also have on occasion a third day tacked on to deal with a very specific area that we have received comments upon. For example, on September 14th, we'll have it on encryption area, and that will be out in California. We also have in-depth ones on technology controls and our USML, U.S. Munitions List to Commerce Control List events as well. So these are very specific, in-depth, one-day events that we do put on as well. Last pitch I would say is that for many of you that have been doing this for a while, I make a suggestion that we certainly are open to your opinions. We solicit your opinions. Tim will talk about some of the advisory opinions and some of the public opinions that many of the regulations have. We look forward to your input on proposed regulations that are coming up. We also look forward to having participation, and we welcome your participation and membership in many of our technical advisory committees. Melissa mentioned about one that I'm involved in, which deals with emerging technologies, but we also have ones on IT, sensors, materials, and so forth. And this is a group of people that are involved in export controls with their company who, by sitting on these committees, can impart their knowledge on areas of our regulations that maybe need to be changes, added, and so forth. So we do have a section on our website dealing with the Technical Advisory Committee, and I suggest you may want to take a look at that and for possible interest. With that, I would like to turn the event over, the webinar, to my colleague, to Tim Mooney, who is with our Regulatory Policy Division here at the Bureau of Industry and Security. Tim doesn't look like you have many slides on there, but it looks like he has a lot of material to go over, so I'll hand it over to you.
Great. Thanks, Steve. Yeah, so for this program, we wanted to take a little bit of a different tack than our normal outreach program that we do, where we have lots of slides that we go through, kind of getting into more of an in-depth, hitting on some key things to keep in mind. In terms of the revisions that have occurred to the State Department's United States Munitions List as well as the Commerce Control List, as Steve had mentioned, of course, if there's ever a question of jurisdiction, there's the commodity jurisdiction process, which the Department of State is in charge of, making those determinations with industry, with input, of course, from the other agencies. But ideally what we've done in terms of the revisions to the State Department's control list as well as to the Commerce Control List, the Commerce Control List already was in many ways a positive control list. But what we've done is gone through the USML and turned it as much as possible into a positive control list. And the idea with a positive control list is that if you know the technical parameters of your item, you should be able to look at that control list and make a determination whether you're subject to the ITAR, or if not subject to the ITAR, whether you're subject to the EAR or not. So using positive control parameters where you know the capabilities of your item, you can look at it and say, yes, I meet that control parameter, or no, I don't. Now, in certain cases, we do need a broad catch-all. So, for example, like with the F-35, when you're talking about a crown jewel in the U.S. export control system, obviously the F-35 is something that we care very much about, and specially designed parts or components that go into that F-35, of course, those would be ones that would be subject to the ITAR and over on the ITAR. So we have the definition of specially designed under the ITAR, to make sure that those specially designed parts or components, for example, to the F-35 will be subject to the state jurisdiction and regulated by the State Department. And then on the CCL, moving those items over that didn't warrant ITAR control, those military items as well as the spacecraft-related items that didn't warrant ITAR control under to the EAR, then again, controlling them with positive control parameters, and then when needed, using the broad catch-all with specially designed but based on objective parameters that you can ask a series of yes-no questions to get to that determination whether you have a specially designed item or not. So I'm going to talk a little bit about special design. I'm going to talk a little bit about some of the regulatory activity that we've been going on in the new administration as well as in 2017. With the beginning of the new administration, the pace of the rules that we have been publishing has slowed down initially. We've published since January 20th, 2017, we've published 10 rules. As Steve had mentioned with the entity list, and this is actually typical for us, a lot of our regulatory activity does involve changes to the unverified list or changes to the entity list. So if you look at the 10 rules that we've published since January 23rd, 2017, 5 of those rules have involved the entity list. So half of the rules involving changes to the entity list. Now, we just published last week on July 17th, we published our first regime implementation rule for the missile technology control regime. And our control list, the heart of our control list is really based on the 4 control list of the multilateral export control regimes, the missile technology control regime, the nuclear suppliers group, the Australia group, as well as the Wassenaar arrangement for the national security controlled items. So we just published our first regime rule under the new administration for the missile technology control regime. It made various updates to 10 or 12 ECCNs. The missile technology control regime rules, usually are much smaller in terms of the overall length compared to like the Wassenaar arrangement, which tend to be very large rules. The next rule in terms of the regime rules that you'll see is the Wassenaar arrangement, which is we expect to be published hopefully sometime in the next couple of weeks. That'll be published. Now, I do want to alert you that you are going to see a change in the way that our rules are published. The Federal Register has what they call the Document Drafting Handbook, and that basically sets the rules for how the regulations are amended when we publish the actual rules. And the update that they made to the Document Drafting Handbook, which became effective on Monday of this week, is going to result in a change in how we amend ECCNs. So when you have a regime rule like the Wassenaar arrangement or the missile technology control regime or any other rule, typically what we've done in the past is we've only set out in the regulatory text in the Federal Register the paragraphs that were being revised. So with our ECCN, if we're revising ECCN 3A001, which in the Federal Register goes on for pages and pages, the only text that would be set out would be the paragraph that was being revised. So if we're revising ECCN 3A001 items paragraph A1, the only regulatory text that you would see would be the heading of 3A001 and then the revised text in 3A001. We're no longer going to be able to do that. So going forward, the instruction would simply be revise ECCN 3A001. So you're going to see the regulatory text is going to be very, very long because you're going to see the whole entire ECCN being revised. How are you going to know what part of the ECCN is actually being revised? A very practical question. And what we're going to try to do is we'll say this regulation amends ECCN 3A001, but then what we're going to try to do is do a parenthetical to say these are the specific parts of 3A001 that you need to be concerned with. In addition, the preamble of the rule also will identify what are the specific changes in the paragraphs that are being updated. But that's a change that you'll see. So when we publish that Wassenaar rule in a couple weeks, most likely you're going to see it'll be a fairly long rule because you're going to see each of those ECCNs that are amended will be fully set out. It doesn't change in terms of anything else how we do our rules, but the rules will look different. So when you review those, the importance of reviewing the preamble will be more important, and we are going to try to help you with adding additional text to the amendatory instruction. We're going to have to talk with the Federal Register to see if they'll actually agree to that, but we think that that would be a practical compromise which would help us to be consistent with the document drafting handbook while at the same time helping people that need to comply and understand the regulations. So in 2017, during the new administration, we've published 10 rules, as I had mentioned. In 2017 overall, we've published 17. Now on average, we typically publish anywhere from 30 to 40 rules. And typically with the new administration, as you settle into a new administration, as you get new politicals, then we get guidance from them in terms of, what are their priorities, things like that. Typically the rulemaking, picks up a little bit as we get into it. As I had mentioned, we've done 10 rules. 5 of those were entity list related, an authority sites update. The most significant one was the publication of the Missile Technology Control Regime, which made various updates. In terms of things coming down the pike, we're working on notices of inquiry. One notice of inquiry that the State Department and the Commerce Department are working on, and that'll be for categories 5, 10, and 11. 11 is the military electronics. That's always of great interest to people. That'll be a notice of inquiry. The State Department's working on theirs. Commerce is working on theirs. Now, the idea of a positive control list, that's a good thing. It makes life easier for everyone. It's a much clearer line. But when you start having positive control parameters, those need to be updated on a regular basis. Or, maybe the government has missed something that's not as clear as what we had originally thought when we had updated the USML or as well as the State Department. Those notices of inquiry, that's an opportunity for you to provide that information to the Commerce Department as well as in response to the State Department's notice in response to categories 5, 10, and 11 when they do get published. We're also working on another notice of inquiry for USML categories 6, 7, 13, and 20, which the State Department's working on, and then for the corresponding military ECCNs under the CCL, we're working on our notice of inquiry. When those come out, that's definitely a good opportunity for you to, if you have items that are under either those USML categories or the 600 series on the CCL, to provide those comments. When we get those, that helps us to figure out whether we need to do a proposed rule to make changes. So that's kind of the initial step. And then once we do that, then we do a proposed rule. Again, you'd have another opportunity to come in with comments, and then moving to a final rule. A couple other things that we're working on. We have a correction and clarification rule for license exception STA and license exception GOV to make some clarifications to those. For those of you that have listened in the past to our telecom conference that we did, the highly successful teleconference, we had a lot of Q&As about STA as well as license exception GOV. For example, the completing of the chain concept. For the military items authorized under license exception STA. We've answered a lot of questions on that in the past, and what we're going to do is actually add a clarifying note to STA to make that clear. The prior consignee statement. You can have more than one party on a prior consignee statement. That's a longstanding agency practice in terms of that, but we're going to make that clear in license exception STA to clarify that if you have a manufacturing network, you have one person in the UK, one person in France, one person in Germany, you're all part of the same manufacturing network, you don't necessarily have to get a separate prior consignee statement from each. You can actually use one single prior consignee statement, get all the parties to sign off on it, and then you're going to meet that requirement. As I had mentioned, we've done FAQs in the past on this as part of the telecons and our outreach program, but what we're going to do is we're going to clarify that in license exception STA, along with some other clarifications to STA as well as license exception GOV. We're also working on a proposed rule to create a new process, and this would be a proposed rule. Currently, when you apply for a license, you have to stay within the scope of the license. What's included in the support documents that come in, that license that's issued. If you want to make any change that goes outside of the scope of that license, the only time that you can make a change are those exhaustive listing of changes, which are in 750.7 paragraph C1. Those are the only ones that you can self-determine are non-material, and you don't need to come in for a replacement license. We did add 750.7C2 to allow for certain name changes. And we use the advisory opinion process currently, and we get quite a few of those. We get anywhere from about 10 to 15 of those a month, where people are coming in, they've made a branding name change, for example. That would have in the past created the need for a replacement license. But we have a way to do that through the advisory opinion process to allow people to come in, say, this is the change for branding reasons, or if there's an intra-company merger, for example, with two wholly owned subsidiaries, you've merged them in together, and as part of that you've renamed it. You can come in, you describe the change to us through the advisory opinion process, you identify all the licenses. If we review it, if we agree that's within the scope of 750.7C2, we can approve that through the advisory opinion process. There's a whole part that you have to do with export clearance, with sending out that response to other people. When you fill out the AES record, you do the new name, formerly known as the original name that was on the license. We think we can do better, though, and we think that we can give you even more flexibility to make the process more efficient for the U.S. government as well as for exporters. And what we want to do is we want to create a formal process to allow people to use the SNAP system to request license amendment changes. And we have a draft rule which is out. Right now we're working with the other agencies to refine the proposed rule, which we hope to have interagency clearance hopefully later in 2017 and have that proposed rule out. And that will basically create a formal process in SNAP-R to allow you to request those license amendment changes. And what we're going to do is we're going to take the existing name change process under 750.7C2, move that into the SNAP-R process. License transfers, which are currently done on paper, where people send those in and we respond back. We want to pull those into the SNAP-R process also. And then extensions of license validity. Again, we want to pull those into the SNAP-R process. We are also looking at the idea of giving you the ability for a license amendment request to change the parties to a license. So we've added the ability now to have these very large licenses, sometimes with hundreds of parties on the license. Remember what I said, if you make one change to a license, you're going to have to come in for a replacement license. The changing of a party on the license, that's not in 750.7C1. So you have 200 people on the license, you have to change one person out, or you need to add one additional end user. Now you need either a new license or a replacement license. But the U.S. government's already reviewed the scope of the activity. We were comfortable with it. All you want to essentially do is request to add that one additional party. So what we want to do is create a formal process to allow you to come in and request those changes. And we hope to have that out, as I said, as a proposed rule in 2017. And as I said, we have a draft rule. It's out for interagency review. We hope to have that out later in 2017. So in terms of recent rules, a lot of the changes, those that have been involved with export controls over the last 6 or 7 years, it's been a very active period. So I think for a lot of people, probably having a little bit of a slowdown is probably comforting. As you get comfortable with the various changes that have come into place, and we're trying to help you as much as we can. The last really big rule that we had was the definitions rule, which was published in 2016. It became effective September 1st, 2016. That made various cleanup changes as well as some conforming changes with the ITAR. It added some new provisions to the EAR also, in particular under 734.18 and 734.20 to address certain cloud-related issues. That we have FAQs on the BIS website that define certain key terms with the ITAR, developing harmonized definitions. That rule is very important. Definitely encourage you to read also the preamble as well as the FAQs to that. The definitions rule made changes to the the scope of the year under 734.3b3. Some of that was just moving things around. Other things were, making various clarifications. It also added some additional things that previously weren't excluded, like system information and telemetry data was excluded from the scope of the year in the new criteria under 734. We adopted some changes to the definition of export, re-export, added those in new sections in 734. We moved the transfer in country into, instead of being an ancillary definition under the definition of transfer, we actually moved it into its own section in Part 734, lining up our definition with the ITAR. Now, sometimes we get confusion under the air with export, re-export, and transfer in country. The scope of the regulations, they do apply to exports, re-exports, and transfers in country, but there are also some very important distinctions with transfers in country, which sometimes sail over people's heads and they get confused. So, for example, license exception STA includes various references to transfer in country, and yes, you can use license exception STA to authorize a transfer in country. But when is a transfer in country subject to a license requirement? And this is a key distinction. The CCL-based license requirements apply to exports and re-exports. They don't apply to transfers in country. So when you're doing your analysis of part of the classification, looking at Part 742, 746, those license requirements are driven by the classification of the ECCN or the Year United Destination, as well as the CCL-based license requirements. Those apply for exports and re-exports. A transfer in country is not subject to those CCL-based license requirements. So when do you run into issues under the ear with transfers in country? Our end use and end user controls in Part 744, many of those do apply to transfers in country because of the concern with those parties. We don't care if it's just a transfer in country. We don't want that party on the entity list receiving an item that's subject to the error if it's a license requirement for all items subject to the error. So typically when you're going to run into a license requirement is going to be under Part 744 for those end use and end user controls. Now, with the Crimea region of Ukraine, under Part 746, we had such a concern, and we wanted to make sure that the items that were already in Crimea weren't going to be able to be transferred in country to people that were acting on Russia's behalf there, that we also, for the license requirements for Crimea in 746.5, we did include a license requirement for transfers in country. Now, most people, when you're going to run into a license requirement, an authorization requirement for a transfer in country outside of that would be if the item was authorized under a BIS license. A license, if you're going to go outside of the scope of that license, you're going to require an authorization under the EAR. You can use a license exception under the EAR to authorize a transfer in country. So, for example, if you received an item under a license to a UK defense manufacturer, and they were going to be manufacturing items for, other companies, etc. But then subsequently, they get an order from the UK military, and the UK military wants to have them sell to another manufacturer who's going to be making an item for the UK military. That other manufacturer is not listed on a license. They're going to need an authorization to transfer in country because they're going outside of the scope of the original license to that other defense manufacturer. License exception STA, in that case, could actually be used to authorize the transfer in country in that case, provided it wasn't issued under restriction under 740.2 and it met all the other requirements of STA. So in that case, they would use STA to authorize the transfer in country to that other defense manufacturer. Now, if that other defense manufacturer, they want to transfer it in country to another UK manufacturer as they're doing this manufacturing chain before it gets to the UK military, those subsequent transfers in country do not require an authorization under the EAR. So you could transfer in country 6 or 7 different times to those different defense manufacturers, and in those cases, you don't need an authorization for those subsequent transfers in country. Now, ultimately, the chain needs to be completed, or you'd need a separate authorization. So, eventually, you would need to go to the UK military in that scenario. Now, do you need a separate prior consignee statement for each of those additional parties that are receiving it in the chain? No, you don't. You would need, for the initial transfer in country that was authorized under STA, you would need the prior consignee statement, but those subsequent transfers in country within the UK, you wouldn't need separate prior consignee statements. Now, if the UK manufacturer that received it under STA, if they wanted to go to France as part of that manufacturing chain, then they could use STA to authorize it to go to France, but they would need a separate prior consignee statement in that case, as well as another prior consignee statement for the prior consignee that would receive it in the UK. But for those subsequent steps in the chain in the UK, they would not need the prior consignee statement and they would not need a separate authorization, but the chain would need to be completed. So transfers in country, sometimes you may need an authorization, and you can use an EAR license exception in many cases to authorize a transfer in country, but in general under the EAR, you're not going to require an authorization for a transfer in country. The other place where you would run into a requirement for a transfer in country would be if there was a knowing violation. So there you're looking at General Prohibition 10 as well as 764.2 paragraph E. Once that item is tainted, even a transfer in country is going to be prohibited, or any type of servicing, etc. Any verb you could come up with is going to be prohibited because that item was involved in a tainted activity. So that's just a little bit of background, on the current recent regulatory activity that we've been involved with, as well as some things that we look at that will be coming down the pike. Now, in terms of specially designed, that's another area that we do get some questions on. That has actually died down significantly. As people have become familiar with the catch and the release construct under the ITAR as well as the CCL, we have various FAQs that are up on the BIS website. But essentially it's tied in with the order of review, and that order of review, starting on the ITAR. You're always starting on the ITAR, doing that analysis, looking at the ITAR first, and then you're just going to step down the stairs, going through the jurisdictional analysis and then the classification analysis as you go through the stairs. First, looking at the USMO order of review, looking at paragraphs that don't use specially designed. If you see it described on the USML in a paragraph that doesn't use specially designed, you stop there, you have a defense article. You're looking at the ITAR's control list and the ITAR provisions. However, before you leave the ITAR, you may be confronted with a paragraph that uses specially designed. Now, specially designed is not used nearly as much on the ITAR compared to the EAR, but there are certain paragraphs where it was warranted to have a very broad catch-all, like for example, in USML Category 8H, for certain stealth aircraft, specially designed parts or components, like for the F-35, there it was warranted to have a broad catch-all based on specially designed under the ITAR. A couple key things to keep in mind. So both the ITAR and the EAR both use the term specially designed. You only need to do a specially designed analysis if the paragraph you're looking at uses specially designed. If the paragraph that you're using doesn't use specially designed, you don't care about specially designed in that case. So only look at specially designed when you're looking at a paragraph that uses specially designed. The two definitions are structurally similar. They're both based on a catch and release construct. If you're familiar with one, you'll be familiar with the other. However, if you're doing the ITAR analysis of specially designed, you're always using the ITAR specially designed definition of specially designed. You're only using the EAR specially designed definition when you're under the EAR, doing that analysis as you go through the USML order review and then the CCL order review if you're not subject to the ITAR. So those are two very important things. A couple other key things to keep in mind. Just because you're not subject to the ITAR and not specially designed under the ITAR that does not mean that you're not specially designed under the EAR. You're going through this cascading review, starting with the USML order review, first those paragraphs that don't use specially designed under the ITAR, then doing the analysis of the paragraphs under the ITAR that use specially designed. This is very important because the ITAR releases from specially designed, in particular the production release under paragraph B3, and then the development release under B4 is broader in its scope in what gets released compared to what's under the EAR's production release under paragraph B3 as well as our B4. Right, under the EAR, the production release, you're doing the analysis, is that part, for example, is it used in a military aircraft as well as an ER-99 item that's in production or an AT-only item that's in production? Under the ITAR's production release, you're doing the analysis of that part that's used in the F-35. Is it used in the F-35 and in an item that's not on the USML? So if it's an aircraft that's in production that's not on the USML, it could be a 9A610.A aircraft. So the part's common to the F-35 as well as the 9A610.A aircraft. That part is going to drop off of the ITAR specially designed definition. But where's it going to get pulled into? Most likely it's going to get pulled into specially designed under 9A610.X. because it's used in a military aircraft. So you know it's going to meet the A2 catch under the specially designed ER definition, and then the question would be, does it get released because it's common to an AT-only aircraft? So for example, that same exact part, I'm doing the analysis under the ITAR. I say, well, I know it's used in the F-35, but I also know it's used in a 9A610.A old Huey helicopter that's in production. So I know it's not specially designed under the ITAR. I come over, I start doing more analysis under the CCL, and then I say, well, wait a minute. I also know that this is used in a civil aircraft, which is under 9A991.B. So then I know I drop out of specially designed for purposes of 9A610.X, and then I'm doing, as I do go through that cascading review, I'm going to run into specially designed one more time under 9A991.D. For the civil aircraft, doing a specially designed analysis. So it may not be specially designed under the ITAR. It may not be specially designed in 9A610.X as a military specially designed part, but it may be specially designed under 9A991.O as a specially designed aircraft part. Now, if that same part is also common to AT-only school buses, not school buses, but AT-only vessels or vehicles that are ER-99, then that are in production, that would drop out under paragraph B3. So again, the importance of the order review, always starting under the ITAR, doing that analysis. When you come over to the CCEL, you're doing your analysis. First, you're doing the analysis of the 600 series and the spacecraft-related ECCNs. Why is that so critical? Because we changed the order in which you normally would review those control lists, the CCL categories. Before we started moving the military and the spacecraft-related items over, you always went to the beginning of the category and then just started working your way back until you get to ER-99. Now we've pushed right into the middle of those respective categories, the military items as well as spacecraft-related items. So what we want you to do is under the order of review, at first steps 1 and 2, you're looking at what's the category, what's the product group, as Steve went over earlier. And then once you know that, you're looking at those military ECCNs first, as well as the spacecraft-related ECCNs if applicable, and looking to see, again, just like you did under the ITAR, do you see it enumerated or described in a paragraph that doesn't use specially designed? It's yes or no. If it is, then you have a specially designed military item, and you stop there. That's your classification analysis. However, before you leave the 600 series or the spacecraft-related ECCNs, you're going to run into, most likely, a paragraph, usually in the .x paragraph or the .y, that uses specially designed. And you would have to do the analysis of specially designed for that before leaving those paragraphs. And you're using the ER definition of specially designed. It's based on the catch and the release construct. A couple of quick things to keep in mind with that. With paragraph A2, if you have a part or a component, you might as well just skip right to that. Is it used in a military aircraft, yes or no? If it's a yes, then you know you're doing that release analysis under paragraphs B1 through B6. Now, if you know at the outset, though, that that item is a screw or a bolt, well, you would know right away that that's not going to be specially designed under the ITAR or any paragraph on the CCL that uses specially designed. So in that case, you wouldn't even worry about paragraph A. You would just go directly to paragraph B2, and you could just cut that out of your analysis. Or if you know at the outset all of these parts are used in civil aircraft that are in production, well, you're not going to need to worry about any of the 600 series ECCNs that use specially designed, because you're going to know that for those specific parts, they're going to meet the B3 release. So that's what we refer to informally as the reviewing paragraph B first. So in certain times, it may make sense to review paragraph B, the release provisions first from specially designed, before you do that paragraph B analysis. Now, one of the things with specially designed, the first time you look at it, it does look a little bit long, and one of the reasons why it looks fairly long is because of the various notes. And those notes are there. They help to define certain key terms and some application examples to help you to understand how to understand the definition of specially designed. It's also based on certain other defined terms, like the definition of knowledge. For example, when the development releases under paragraph B5, B4, B5, and B6, that's based on our existing definition of knowledge under the EAR. The production release, that's not tied to knowledge. That's just an objective fact. Is it used in the production of an AT only or an ER9 item that's in production? It doesn't matter with the production release what it was originally developed for. So if it was originally developed for a military aircraft, but it's subsequently used in an AT only item or an ER9 item that's in production, the original development history is not relevant. It also works the other way with the development releases. So if you have contemporaneous information in its totality during the development phase that shows you intended to develop it for use in a civil aircraft as well as for use in military aircraft, but then subsequently, the civil market doesn't want it, and it never actually ends up, being used in a civil aircraft in production, that doesn't matter, because the development release criteria under paragraph B4 was met during the development phase. So if the military is the only people that subsequently wanted to buy that component that was developed for use in military aircraft as well as civil aircraft, it doesn't matter, because that development criteria is based on that. If you do the full analysis of specially designed and you end up at the end and you say, well, I'm caught, but I don't meet any of the release provisions, but I really think for whatever reason my part or component, accessory attachment doesn't warrant being specially designed, what can I do in that case? Well, keep in mind that the way that the definition is structured, paragraph A has to exhaustively capture everything that may potentially warrant being specially designed. The paragraph B releases, in 100% of the cases, the U.S. government has to be comfortable with saying, in all cases, if you meet this criteria, in 100% of the cases, we never want this being specially designed. And that's the way that it's structured. But are there certain cases where a subjective determination could be made, and a case could be made that a part or a component doesn't warrant being specially designed? Yes. And that's where we created the B1 process. So the B1 process is backward-looking as well as forward-looking. The backward-looking addresses if you had a past CJ determination, for example, and the U.S. government said this didn't warrant control under the ITAR and it was on the CCL, either ER99 or not in a paragraph that used specially designed, we wanted to grandfather those in and not pull those back up into specially designed. So B1 addresses those. You got that piece of paper from the U.S. government that says it's not specially designed. Those ones, B1's going to release that from specially designed. the forward-looking aspect of B1, we added this 748.3E process. And there you can come in with an advisory opinion to the Commerce Department requesting a release through the SNAP-R system, requesting release from specially designed for that identified component or part. And there you would give whatever information you think is warranted. It's not that difficult to build. It doesn't really have that substantive an impact on the functioning of the end item that it goes into. Whatever reason you think is warranted, that's fine. You know, you come in, you make your case, and then if the Commerce Department, the State Department, and the Defense Department all agree, we will respond back and say this item doesn't warrant being specially designed, or we may say we'll downshift the control. So, for example, for 9A515.X, we recently did this several months ago when we published the final spacecraft rule. We added some additional .Y 9A515.Y items, parts and components. And these were ones that basically we had looked through the 748.3E process and said under B1 that they did not warrant being specially designed in a .X paragraph, which would be a worldwide license requirement except for Canada. So what we did was we basically said these are specially designed .Y items. Now the .Y items are distinct because there, to be in a .Y item, you have to meet the description as well as specially designed. So in 9A610, we have specially designed galleys, kitchens used basically in aircraft, in military aircraft under 9A610 or the USML. Now to be in that .Y paragraph though, it's not all galleys, it's galleys that would meet specially designed. So you have to meet, to be in a .Y, you have to meet the description as well as the specially designed definition for purposes of the EAR. So as we talked about, we wanted to go into a little bit of a different format than we normally do. Steve went and kind of gave us a nice overview of some key provisions to keep in mind with the EAR. I gave you a little bit of a flavor for some of our regulatory activity that we've been involved with in 2017, as well as the new administration. Also gave you a little bit of an overview of some of the things to be expecting coming down the pike. And now Peter's going to give us, from export enforcement, he's going to give us some key things to keep in mind in terms of a export enforcement and compliance perspective.
All right, thank you, Tim, and thank you, Steve and Melissa, for inviting me here today to speak with you about export enforcement. Understanding that our time here remaining is somewhat limited, I do intend to keep these following in-depth remarks fairly brief. What I do hope to be able to cover is providing a basic overview of the export enforcement and control community throughout the United States government that will hopefully provide some context for you to see how and where BIS export enforcement fits into the picture. I'll then share with you a little bit about what we do in BIS and identify some red flags and best practices for you to look out for. We will then discuss how you can help us by reporting and disclosing the violations, and we'll leave you with some useful contact points of contact and contact information and references for you to consult after today's webinar. So you can see that the Bureau of Industry and Security is but one agency among other agencies of the United States government with export control responsibilities, as you can see here depicted on the slides. It's maybe worth noting here that some of these departments and agencies control exports in ways that may overlap, in fact, with BIS, and the list continues on to the next page. So you can see there are quite a few agencies of the United States government that have various equities in administering their various export control responsibilities. You can refer to the source down there at the bottom, supplement number 3 to Part 730 of our regulations for more detailed contact information for these respective agencies. So you're probably wondering how all these agencies work to address the overlapping jurisdictions. And so shortly after a comprehensive review of the export control system was initiated back in 2009, the United States government created the Export Enforcement Coordination Center, the E2C2, and you can see there that the Department of Commerce is where the Bureau of Industry and Security Export Enforcement fits in, and we do and are one partner agency of the E2C2. And so with this broad-based orientation of the export enforcement and control community, we can now turn to a more in-depth discussion on Bureau of Industry and Security export enforcement. Before we get into the export enforcement piece, you can see that the mission here of the Bureau of Industry and Security is really twofold, that of both ensuring an effective export control and compliance system, while also at the same time promoting U.S. technology leadership, which we accomplish in part through the partnership that we maintain with industry. Here's an organizational structure of the Bureau of Industry and Security, and you can see the box circled down there in the lower right-hand quadrant of the page is where export enforcement sits. Situated within BIS, export enforcement, or EE, accomplishes its mission through a law enforcement program focused on sensitive exports and trade practices of concern. What makes EE unique is its ability to not only pursue criminal violations, but to also impose administrative sanctions as well. You can see that EE consists of three primary offices: OEE, OEA, and OAC. And along with our colleagues in export administration, side of the Bureau, EE personnel applies our unique subject matter expertise to prevent and deter unauthorized exports and transactions that may jeopardize our national security and foreign policy interests. Another closer look at the organizational chart for BIS export enforcement. You can see the three subcomponent offices there of OEE, OEA, and OAC. But before going into the Office of Export Enforcement, I would be remiss if I did not mention what the other offices in BIS Export Enforcement do. And so turning first to the Office of Anti-Boycott Compliance, you can see that they are charged with administering the restrictive trade practices or boycotts section of our regulations that are found in Part 760 of the EAR. Among other things, anti-boycott laws prohibit U.S. companies from supporting unsanctioned foreign boycotts. In enforcing these laws, we prevent U.S. firms from engaging in certain conduct that would be used to implement foreign policies of other nations that run counter to U.S. policy. And of course, of primary concern today is the Arab League boycott of Israel. Compliance with certain requests to engage in restrictive trade practices may be prohibited by the EAR and may be reportable to the Bureau. Should you have any questions about OAC or the regulations that it enforces, you can contact its hotline listed there or submit an inquiry through the BIS website. Turning next to the Office of Enforcement Analysis, or OEA, you can see that they support BIS by providing all source information to both inform the license adjudication process, as well as prevent diversion of controlled items abroad through its end-use check and outreach programs. OEA also supports law enforcement efforts by identifying potential violations and forwarding investigative leads to OEE. OEA carries out its analytical function through 4 program offices identified here: IAD, IOD, the SID, and through its ECO program. And lastly, we have the Office of Export Enforcement, or OEE, the office in which I work. It's worth noting here that OEE is the only federal law enforcement agency that is exclusively dedicated to the enforcement of export control laws. And it's that singular focus that allows us for the development of the requisite subject matter expertise to be able to effectively enforce a complex regulatory regime. We are sworn federal law enforcement officers with the accompanying law enforcement authorities, along with our ability to detain and seize items that are about to be illegally exported, and to also order the redelivery of items to the United States that may have been already illegally exported. As will be mapped out on the next page, you can see that we have 8 field offices, along with resident area offices and other locations that are deployed to joint offices with the FBI and DCIS to more closely cover many of the other cities throughout the United States. And each of these offices do have varying degrees of geographical coverage throughout the United States, as you can see here depicted in this slide. All in all, we have about 10 to 12 agents or so per field office that have quite a lot of territory to cover, as you can see. And so with these resources, you're probably wondering how we cover such a large area and how it is that we accomplish our mission. And the answer to that question really rests largely with you and our partnership that we have with you. We do take seriously, very seriously, the information and the reports and leads that you send our way. And with your help in identifying red flags of possible violations, we are able to initiate leads and referrals to our field offices for follow-on criminal investigation. Many times it's industry-sourced information provided to us in the spirit of cooperation that really helps our investigations, and we rely heavily on that information and appreciate you providing that to us. By prosecuting wrongdoers, we try to level the playing field by helping you, the vast majority of exporters who are investing the time, the energy, and the resources in developing compliance programs aimed at really doing the right thing. And so in terms of what you can look for and help us identify possible violations of concern, you can find the list of red flags in our regulations at Supplement 3 to Part 732, Know Your Customer and Guidance and Red Flags. While we don't have time to go through every one of these red flags, I will just highlight a couple of my favorites red flags, and the first being there that the customer or its address is similar to one of the parties found on the BIS list of denied parties or persons, and for that matter, that also applies to the entity list and the unverified list that Tim and Steve alluded to earlier as well. With this red flags, you have to be careful and really conduct your due diligence to know your customer, know what the end use is. The end use with everything is key under our regulations. As part of that due diligence process, please don't call us first. We do ask you to do your duty and inquire into the party that does have that similar address. Try to get as much information from them, as much identifiable information from them to help you resolve as to whether or not they could be a party that is on or maybe related to one of the parties on the lists of concern. Turning on to the next page here, and if you look at the third bullet down where a freight forwarding firm is listed as the product's final destination, when a company's line of business is to forward packages onto another end user, chances are that they might not be the actual end user of what you're sending them. So if they are listed as the end user on a particular transaction, you should ask yourself as to whether or not the level of sophistication of the item is consistent with their technical abilities or their line of work. Again, for more reference, these red flags are found in Supplement 3 to Part 732 of the regulations that's listed at the bottom of the slide here. And so if you do identify a red flag, do not stick your head in the sand and self-blind yourself. You are to decide whether or not there's any red flags with a particular transaction and exercise your due diligence and inquire into the transaction of concern. After your inquiry to learn more about your customer, you can then reevaluate the information and assess the risk of the particular transaction and decide whether or not to proceed or not to proceed. And if you do refrain, please do report that information to us. And also at the same rate, if you may have already committed a possible violation concerning the transaction of concern, take the appropriate remedial measures, and we encourage you that you disclose the conduct to our office. If and when you decide to report a violation, you can do so through either our website or our 1-800 hotline number listed here. To report the violation through our website, you can pull up the main website, www.bis.doc.gov, and notice towards the bottom right-hand corner of the screen there is an icon to report violations with our Department of Commerce badge on it. If you click on that icon, it will take you to the page where you can enter the appropriate information concerning your transaction of concern to report that violation to our office. Briefly, if you or your company has committed a possible violation of our regulations, we do encourage you to report that and disclose that conduct to our office in accordance with 764.5 of our regulations. Just briefly, the process is such that we understand that at first blush you might not always be able to definitively conclude that an actual violation has occurred, and so we encourage that you provide us with an initial notification of a possible violation. We then enable you 180 days to be able to conduct your inquiry, more thorough inquiry and review, to be able to submit a narrative account of disclosure that fully describes the circumstances of the potential violation at issue. If you're not able to complete your review and compile your disclosure within that 180-day timeline, there is a provision in the regulations that enables us to extend the deadline if you submit a formal request to do so. Another point here to consider under the disclosure program here is the provision at the bottom of the slide here, 764.5F, which deals with the treatment of unlawfully exported items after a voluntary self-disclosure has made. And basically, any person who has made a voluntary self-disclosure knows that a violation may have occurred in connection with that item. Therefore, in order to take certain activities that would otherwise constitute a violation under 764.2E of the regulations, we encourage you to come in and request permission from BIS to engage in those activities. And the request is considered by the Office of Exporter Services in consultation with the Office of Export Enforcement. So now that you have either reported or disclosed a violation to our office, you're probably wondering what type of response we take. This summarized list of responses, from taking either no action or even going down to a criminal referral, are spelled out in greater detail in supplement number 1 to Part 766 of our regulations concerning the guidance on charging and penalty determinations in the settlement of administrative enforcement cases. Other types of administrative sanctions or protective measures that we can also pursue are listed here. One thing to highlight at the bottom there is the imposition of a training and audit requirement that can be imposed as a condition of settlement. And what that does, and that was recently memorialized in the revised guidance that was published last year, June 22nd, 2016, on the revised guidance of our enforcement cases. What the training and audit requirement does is it enables a portion of a potential monetary settlement to be suspended or waived in part based on the companies agreeing to enter into certain training or audit requirements. So just a quick plug here before I wrap up to enable some time for questions. With our publication here, Don't Let This Happen to You. The publication is depicted at the upper left-hand portion of this slide. It contains description on our various enforcement cases. Also provided for your reference here are different links to other websites as well as BIS's website for other types of consent agreements and description of export control and sanction cases. So if you want to ensure that does not happen to you and you don't wind up listed in our publication, Don't Let This Happen to You, general things to follow here. Know your customer. See Supplement 3 to Part 732 of our regulations, and as Steve noted before in his presentation, to be able to see the consolidated screening list and ensure that you're not engaging in any other activity under 744, Section 744 that Tim mentioned. And again, help be our eyes and our ears and watch for red flags. You're out there, you see these things many times before we do, and so we do ask that if you are able to identify a red flag and not be able to resolve it yourself, or if you need assistance in resolving that red flag, please do report the conduct to our office, or if you actually may have committed a violation, please, we do encourage you to disclose those violations to our office. And lastly, have an effective export management and compliance program in place as well. And so with that, I'll turn next to some contact information, and I do believe these slides will be provided for your reference, so apologies if we're going through these in a relatively quick manner. And with that, I'll just wrap up with a list of useful references for you to consult and consider after this webinar.
Great. Thank you, Peter.
Thanks very much, Peter and Stephen and Tim. I'll remind folks that to ask a question, you can hit *1 and record your name, and then your line will be unmuted. And while we wait for the first question, we do have a question that was written in the queue, and that is, would the eCFR website be the most up-to-date version of the EAR to consult?
Yeah, that's a good question. So the eCFR is what they call the Electronic Code of Federal Regulations, which is the beta site, which is basically the electronic version of the hard copy CFR book that gets published. The eCFR gets updated generally about 2 to 3 days after the Federal Register notice appears in the regulations, in the Federal Register. BIS, we typically try to get our files maintained on the BIS website updated the day that the rule gets published. Now, depending on the rule, like the Wassenaar rule tends to be very large, it takes a little bit longer to do the incorporations. So sometimes the eCFR may be quicker than the Commerce Department, but probably about 70–80% of the time, like especially with entity list rules, we get the files updated usually that morning. So the EAR BIS files would be quicker. The two sets of files, the eCFR as well as the hard copy CFR as well as the BIS website, should be identical. Now, sometimes, that you may see an incorporation error or something like that. If you ever do see something like that, we highly encourage you to contact us, and then we'll do whatever needs to be done to correct it, either on the eCFR end, if it was a problem with the Federal Register editors making the incorporation, or if it's in our EAR files that we post. Now, we did do about 6 or 7 years ago, we actually got rid of our EAR files for about 6 months, and we relied on the eCFR. And people absolutely hated it. We got lots of complaints. The eCFR formatting, though, has actually gotten a lot better. So we'll see maybe later. Maybe we'll look at that idea again, because the eCFR actually is looking a lot nicer than previously when we tried that 5 or 6 years ago. But we know that the public likes the files that we maintain on the BIS website, so we'll also, of course, take that into consideration.
And operator, have we had any questions come in over the phone lines?
Yes, we do have a party holding on the phone. Daniel Blakely, go ahead.
Hi, thank you. Thank you, everyone. The presentations today were really helpful. And Melissa, thank you for everything you've done to put these together. I have a very quick question. Mr. Mooney, you referenced those extremely helpful and well-received weekly conference calls that used to take place. And I can tell you I run an export compliance networking group in the Denver metro area, and those calls come up almost every time that we meet. People would very much like to see those put back into place. Do you all foresee that happening?
It's a good question. And yes, we have also heard a lot of people ask that question and also make that suggestion. At this time, we just have an acting assistant secretary at this point, and the same with an acting undersecretary. I think once we actually do get our politicals in place, then at that point they'll kind of evaluate, what they want to do in terms of the outreach. I would emphasize, though, that as former Assistant Secretary Wolf doing that, generally every Wednesday, it was a significant time commitment for the Assistant Secretary. So we'll have to kind of see in terms of the priority for the new people that come in, if that's something that they, want to continue or not. Now, of course, if you want to make a suggestion, to send that into BIS when we do get the new Assistant Secretary, of course you're welcome, you're welcome to do that. But I do want to emphasize, though, that in some ways it was kind of a unique opportunity, that former Assistant Secretary Wolf, did spend the amount of time that he did out of his schedule. I mean, because an Assistant Secretary or an Undersecretary, they do tend to be very busy and have lots of, meetings and things like that. So, setting aside time every week to do it, I mean, it was a wonderful thing, but we'll have to kind of see in terms of the new people that come in if that's, one of the things that they're interested in doing or not. Now, that being said, we are, as part of our regular outreach, we are working on the idea of building out those decision tools that Steve went over. We have a draft one for the deemed exports, which we're going to get out before the end of this year. And then the idea, what we want to do is we want to turn those decision tools into an integrated ER decision tool suite. And basically, it would kind of seamlessly integrate you from tool to tool. So as you determine the classification, we want a tool to help walk you through the steps for determining whether a license is required. We have the STA tool, but also to kind of do tools to walk you through the different license exceptions. And that's something that we are currently actively working on to help you.
Let me also mention for the questioner, and that is that our update conference typically is dealing with policy issues, and we have this in the fall. It is our largest event that we put on, typically attracting over 1,100 export control administrators, people from companies, and attracting over 35 or so exhibitors. This is an ideal time, actually, for those on the phone, on the webinar, to attend, to actually meet with some of your export licensing officials, but also people from the export enforcement office as well. Many of the field offices that Peter talked about will send representatives over, as well as some people from your offices overseas as well at Update. I encourage you to take a look at our BIS website on a regular basis to get the announcement and the dates for the next one, which will be coming up in the fall. Are there any more questions at all, Melissa?
Operator, have we had any other questions come in the queue?
No further questions on the phone.
Stephen, Tim, Peter, did any of you have any final thoughts before we close the webinar out?
Yeah, I think one thing I would emphasize is just the importance of staying involved with the process. In terms of developing an effective compliance program, it makes things a lot easier. Participating in this webinar today, document that as part of your compliance program. For the people that did participate in the webinar, go back to your office and, if you have a weekly meeting or something like that, give 5 minutes of some of the key things that you learned, and then again, document that as part of your compliance program, because that's one of the effective elements, of a compliance program is that you're attending seminars or taking other steps to make sure that you're keeping up to date with the regulations. The same thing, if you're checking the ECFR, you're signed up for when we publish Federal Register notices, you're getting that email, document that as part of your compliance program. So then, if somebody from Peter, from Export Enforcement like Peter comes to talk to you, or one of our agents, you're gonna be confident that you've done what you should be doing. And we know that you're dealing with people all over the world. Are people going to lie to you? Yes, people are going to lie to you sometimes, and you're going to act in complete good faith. But what you want to make sure, though, is that you ask yourself those key questions. Did you have the jurisdiction right? Did you have the classification right? Did you look at, what were the license requirements for that? Did you look at any potential red flags? And if you've done all of that correctly, you're going to be in a much better position, if somebody from export enforcement, comes and does talk to you. And that'll be a much better conversation compared to if you've, tried to skip steps or things like that, where those conversations sometimes don't go as well.
And I would also encourage for those on the phone and on the webinar, to take a look at our upcoming events that we have on the Trade Compliance and Training tab of the BIS website. We do have it nationwide. We're probably coming to a town near you. The beauty of something like this is that it's a great way to meet with other people that are also export control administrators, but you also get to meet, as part of our presenters, the actual licensing officers. We always have someone from Tim's operation and regulatory and policy area, and we also have one of our local agents as well from export enforcement, as well as a part that affects everybody is from our colleagues at the Census Bureau, the automated export system that is there. So we usually always have a person from that organization in attendance to give that part of the overall program. Peter, it looks like you may have had a question as well.
Sure. So just briefly asking about the processing time for us to be able to review and consider a disclosure. And that the answer to that question really depends on the nature and scope and extent of the violation or violations that are being disclosed, in addition to the content of the disclosure itself. And please do consult the Regulation 764.5 to get an understanding of what we're looking for in the final narrative account to ensure that you're submitting a full, complete, comprehensive disclosure to our office.
At that point, Melissa, that concludes our comments.
Great, and thank you again, gentlemen, for joining us and sharing your insights. We appreciate your time today. And just as a reminder to everyone, we do have 2 webinars coming up next week. On Tuesday, July the 18th, we have a webinar on cybersecurity. And on Thursday, July the 20th, we have a webinar on destination control statements. So we look forward to seeing you all then. And thank you again, and have a good afternoon.
Thank you. That concludes today's conference. You may disconnect at this time. Thank you.